Judge Netburn, is that right?
Yes, sir.
Tell us about a case you had, I think, involving, get my facts right, the transfer of a person, a female, male who became biological male. Does this ring a bell?
Yes, I know which case you're referring
Okay.
to. It was a habeas petition.
Yeah, and it was somebody who had been convicted in '94 for raping a child and a male child and raping a 17-year-old female. They served their sentence. They got out. They were convicted of distributing child pornography. The biological male transitioned into being a female, and the Bureau of Prisons objected to the person going into the female system. Do you remember all that?
I do, Senator.
Okay. And you basically ruled in favor of the petitioner, saying that the Bureau of Prisons' concerns about the intimidation and the threat to female inmates was theoretical. Is that right?
Thank you, Senator. In that habeas petition, I issued a report and recommendation which was based on the facts that were presented to me. Those facts included statements from the 3 wardens who supervised this petitioner, all 3 of whom recommended that the petitioner be transferred to a women's facility because of her serious medical needs. And the Bureau of Prisons...
The Bureau of Prisons opposed this transfer, right?
Well, the wardens who were directly...
No. The Bureau of Prisons opposed this transfer, right?
Correct, which is why the petitioner brought a habeas petition.
Right. So now I'm over time, but I'll wrap it up. The bottom line here is that the concern of the Bureau of Prisons is that a biological male transitioning to a female with a history of sexual violence would be intimidating and threatening to the female population. You thought that to be a theoretical concern because the person in question had attacked male and female people. Is that right?
That's not correct, sir.
That's what you said.
I based my report and recommendation on the record evidence before me.
So you think the concerns of the Bureau of Prison that someone with a violent past regarding sexual assaults would not be threatening and intimidating a biological male transitioning to female? You just don't believe that's a legitimate concern?
Let me be very clear, sir. The crimes for which the petitioner was convicted of 30 years ago are abhorrent, and the petitioner was convicted by an Indiana state court and sentenced.
Well, she was convicted of assaulting a child, raping a 17-year-old woman, got out of prison, and was convicted of child pornography afterwards, transitioned from a male to a female, and the Bureau of Prisons said, we do not believe this person should be in a female prison, and you thought those concerns were theoretical. Is that fair?
I based my decision on the record before me.
You want to finish your statement?
Thank you, Chair Durbin. I based my decision on the record before me. The record was that the 3 wardens who had supervised the petitioner all recommended transfer. The petitioner had had no disciplinary issues at all during her time in federal custody. She had never engaged in any violence and, in fact, had been the victim of sexual violence while in a male facility. And the Bureau of Prisons' longtime treating medical provider also testified during a 2-day hearing before me, who recommended that the petitioner be transferred because of her serious medical needs. I recommended that the district judge adopt my recommendation based on Estelle versus Gamble and Turner versus Safley. The district judge adopted my report and recommendation, and the government did not move for a stay.
Every time this person has had an opportunity to offend, this person has offended. And yet you recommended this person against the recommendation of the U.S. Bureau of Prisons to go to a women's facility. Now, your reasoning here is stunning to me. Going back again to page 44 of your report and recommendation, you say, quote, there are no signs that petitioner is at risk of reoffending. I'm struggling to understand how you could possibly conclude that. Because the minute this person was released, this person engaged in other offenses. Yes, not a contact offense while out on parole, but there are still issues going on. It says nothing. You don't adequately grapple with the obvious fact that this is a 6'2" biological male. Yes, transition aside, the transition didn't begin until age 51 or 52. By then, JJS had acquired all of the physical, biological size and strength advantages of being male. Those don't go away because there is a transition. On what planet does it make sense? On what planet does that person with that sexual offense history, with being biologically male and also 6'2", not pose a threat to the safety of female inmates? I don't understand how you could conclude that this person shows no risk of being an offender. Now, you argue at one point that this person has shown no pattern or history of offending while in prison. Yeah, because JJS was in prison with a bunch of other men where the size and strength differentials aren't quite the same. Can you help me understand this?
Thank you, Senator. First, the crimes for which the petitioner was convicted are horrific. I've been a sitting United States magistrate judge for 12 years. Sexual offenses against children are among the worst crimes that we see. This person was convicted by guilty plea 30 years ago of 2 awful crimes and was sentenced to a very significant prison sentence by the state court judge. About 8 years ago, the petitioner committed another awful crime, the crime of distribution of child pornography. That is an abhorrent crime, and there are real victims. And the petitioner was sentenced by the Indiana federal court.
I understand this. This is all undisputed. What I want to know is, why is it okay? Why is it safe? Why is it fair to female inmates to send this person to a female prison? This is a guy who raped a 17-year-old girl and a 9-year-old boy. Why is that safe? 6'2" biological male.
Senator Lee, as I do in every case before me, I look at the record evidence. I consider the facts before me. In this case, the facts that I considered included that every single warden who supervised this petitioner recommended that the petitioner be transferred to a women's facility because of her serious medical needs, because she had engaged in no violence, no infractions, and in fact had been the victim of sexual assault.
While in a male prison, and this was against the decision of the U.S. Bureau of Prisons.
Mr. McClain raped a child, didn't he?
30 years ago, the petitioner in the habeas case before me,
Did he rape a child?
he pled guilty to that crime. Yes, it's abhorrent.
And then he raped he raped a little boy, right?
I believe that's correct. I believe he pled guilty to 2 acts of sexual violence.
And then he raped a 17-year-old girl, right?
Again, this case was handled by the state court in Indiana, but I
I'm
believe...
just asking you the facts.
I believe...
Don't stall on me now. Did he rape a 17-year-old girl or not after raping a 9-year-old boy?
I believe that's what he pled guilty to.
Okay, and then he went to prison, didn't he?
Yes, the petitioner was...
And then he came out and he sent child porn, basically adults raping little children, to another sex offender. And he was sent back to prison, right?
The petitioner pled guilty to
Was he sent back to prison?
Well, that case was in the federal system, so...
Was he sent back to prison?
Yes, this time to federal prison.
Thank you. And then he decided to transition, and he became a female and started going by July Justine Shelby. Is that right?
Yes.
And Ms. Shelby said, I don't want to go to a male prison. I want to go to a female prison. And the Board of Prisons said, what planet did you parachute in from? You're going to a male prison with this kind of record. And you sent him to a female prison, didn't you? You said that the Board of Prisons was trying to violate Ms. Shelby, former Mr. McClain's constitutional rights, didn't you?
I issued a report and recommendation to the district judge recommending that the district judge transfer the petitioner to a women's facility. The district judge adopted that recommendation.
You said that the Board of Prisons was trying to violate Ms. Shelby's, Mr. McLean's constitutional rights, didn't you?
So I based my decision on the facts that were presented to me in the record
But
evidence.
it wasn't that your ruling?
I recommended finding that under Estelle versus Gamble.
Why won't you admit that was your ruling? Are you ashamed of it today?
I'm not. I'm answering the question. I applied Estelle versus
But
Gamble.
was that your ruling?
My recommendation was that the petitioner's serious medical needs were being denied by keeping her in a men's facility.
By violation of the Eighth Amendment, right?
That's correct.
Okay. And how big was Ms. Shelby, Mr. McLean?
I don't have a specific recollection. Your colleague just suggested that she was
was
more than
6'2"?
6 feet tall.
And you told the Board of Prisons, well, she'll be okay. The other women in the female prison will be okay because it's only hypothetical that Ms. Shelby, Mr. McLean would reoffend again after he's already raped a 9-year-old boy and a 17-year-old girl and has been sending child porn through the mail. You said there's no chance he'll reoffend again. Did you say that?
Senator Kennedy, I based my decision on the record.
But am I
evidence.
right? Did you conclude that?
I don't have a specific recollection of that. I did recommend that after finding a constitutional violation.
What were you thinking in saying it's only hypothetical that she would reoffend?
The facts of the case were that the petitioner had last engaged in a contact offense 30 years ago. The petitioner had not engaged in any contact offense. In addition, the medical evidence made clear that for the last 5 years, the petitioner was sober and hormonally entirely a female, and there was no evidence.
The Board of Prisons didn't agree with you. I'm not going to run out of time here. You're really a political activist, aren't you?
I am not, sir.
But your record demonstrates otherwise.
I disagree. I apply the law to the facts and come to a fair decision. All of my decisions that have been appealed, particularly this one, the district judge adopted my report and recommendation in full, and the government did not move for a stay of the decision.
Well, Judge Netburn, I want to continue on this line of questioning. In your court, what matters more, the rights of individuals or your political ideology?
I apply the law to the facts.
I asked a question, which matters more?
Well, my political ideology doesn't matter at all.
Okay, so I don't believe you. And I think this case demonstrates that you are willing to subjugate the rights of individuals to satisfy your political ideology. This case involves a male defendant who raped a 9-year-old boy. Was he guilty of that?
Yes, the petitioner pled guilty to that.
Okay, so he raped a 9-year-old boy. He also raped a 17-year-old girl. Was he guilty of that?
He pled guilty, the petitioner pled guilty to that crime as well.
So was he guilty?
I hope so, because she pled guilty to it.
He was a he when he did this.
That's correct.
And also criminal deviant conduct, which the record doesn't disclose what that was exactly. Then, after serving in prison, Mr. McLean was released for parole, but then violated the terms of parole by having internet and was sent back to prison. 1 year after being released again, he was convicted of having child pornography. Is that correct?
I'm unclear on exactly the time frame that you're at, but the petitioner was convicted of distributing child pornography.
Child pornography that was images of adults violently raping children.
Abhorrent conduct.
Okay.
For which there are real victims.
And this individual, 6'2", biologically a man. A minute ago you said that when this man decided that he was a she, you said this individual was, quote, I wrote it down, sober and entirely a female. That phrase struck me as remarkable. Did this individual have male genitalia?
I think what I said, or at least what
that is a verbatim quote, entirely a female.
Sorry, what I meant to say was hormonally a female.
Okay, but that's not entirely. Did this individual have male genitalia?
Yes.
So you took a 6'2" serial rapist, serial child rapist with male genitalia, and he said, you know, I'd like to be in a women's prison. And your answer was, that sounds great to me. Let me ask you something. The other women in that prison, do they have any rights?
Is that a question you're
Yes,
asking me?
the other women in that prison, do they have any rights?
Of course.
Do they have the right not to have a 6'2" man who is a repeat serial rapist put in as their cellmate?
Senator Cruz, I considered the facts presented to me, and I reached a decision
I asked you a
based on what
question.
the law
I asked
is.
you a question. Do they have a right not to have a 6'2" man who is a serial rapist put in as their cellmate? Do those women have a right to that?
Every person who's incarcerated has the right to be safe in their space.
But you didn't think so. You didn't think so. And in fact, I'm going to give some quotes from your order because Senator Kennedy is right. This is not a judge's order. This is a political activist. By the way, the beginning of your order says, at birth, people are typically assigned a gender. I got to say that would astonish a lot of Americans. A lot of Americans think you go to the hospital, a baby is born, and congratulations, you have a little boy, a little girl. The assigned a gender, I know you went to Brown, but it sounds like it's in a college faculty lounge with no bearing on reality. The Bureau of Prison argued what I'm saying right now, that if you put this person in a female prison, there will be a risk of sexual assault to the women. And you know what you did? You said you didn't care about the women. I'm going to quote what you wrote. You wrote, quote, the Bureau of Prisons claim penological interest in protecting female prisoners from sexual violence and trauma. This interest is legitimate, that's kind of you to say, but there are no signs that petitioner is at risk of reoffending. The record is devoid of evidence of incidents of violence or assault during petitioner's incarceration when she was the perpetrator, only the victim. A theoretical risk of sexual assault by the prisoner without more cannot support the BOP's position. No evidence, theoretical. Have you dealt, in what universe is someone who is a serial repeat child rapist not at a risk of reoffending?
Senator, as I do in every case,
I know you've been told to repeat the line, I follow the law. I asked a question. In what universe is someone who is a serial repeat child rapist not at risk of reoffending?
sir, I looked at the facts that were before me in this case. All of the evidence, including the statements of every warden who had supervised this petitioner.
You also wrote, the BOP also posits that permitting petitioner to live among women will be traumatizing and possibly dangerous to them. This concern is overblown. I have to say, if I were the father of one of those women, and you decided that my daughter's cellmate was going to be a 6'2" man who over and over and over again committed violent sexual assault, I would say the entire justice system is absurd, and it is clear on your record your political ideology matters a heck of a lot more than the rights of those women that you endangered. I think you're a radical, and I think you have no business being a judge.